And the next is, yes. Part 11 is page 49. So nothing is excluded. There's no specific provision. Therefore, the order says provisions which shall apply shall be as follows. That's why the 54 order says what it says. Provisions of the Constitution which shall apply.
So notwithstanding the deletion of the word only, the word which seems to indicate that these are the parts, the provisions which will apply.
So that's really. Now, in this context, kindly look at the Constitution of Jammu and Kashmir as it was cleared in 1957, passed in 1957. And remember, yes, right.
Publication or government publication?
It's not a government publication, but this is not hopefully not in dispute.
But Mr. Sibal, you are right that the constitutional practice which was followed since the adaptation orders proceeds on the basis that government selectively applied provisions of the Constitution to Jammu and Kashmir. They never treated it as if all provisions apply. Though really clause D is susceptible of two interpretations, but the constitutional practice supports what you are arguing. We'll of course have to hear the learned AG on that.
Now, we move on to what happened in 1957 when the Constituent Assembly drafted this Constitution and was adopted. Right. And remember the 1954 order came when the Constituent Assembly was there. They had a choice. They could have said, no, we want
57, what happens at 57? Let's see then.
Yeah, but I'm just saying the Constituent Assembly was constituted in 1951, I think on the 10th of May, if I remember correctly. And then 54 order was passed. They could have said, look, no, we'll abrogate 370 and be part of India without conditions and be like any other state. They chose not to. And you will see that in the Constitution itself. I'll show it's better we look at the Constitution.
There is no dispute about the proposition. 370 remained in the Constitution.
Yeah.
So nobody is arguing that 370 was not there. Otherwise, where was the occasion to abrogate it? Only issue is whether it requires a permanent character, which cannot be touched, or whether there is a methodology, right or wrong. There is a methodology by which 370 can be abrogated.
Correct.
That's the first part of your argument, as I understand.
Correct.
And in the alternative argument is, even if you don't accept my first part of the argument,
the methodology was
wrong.
No, sir, I'm sorry to interrupt, but on this permanent statement, 370 is in three parts. The first part, our argument is, continues, always. Second part is transitory, because it's dealing with what happens before the Constituent Assembly comes in and Constituent Assembly has to ratify. The third part is temporary, while the Constituent Assembly is there. Just putting it in a nutshell, that's our argument.
Yes, you are saying, according to you, 370 is structured in a manner,
yes,
whereby some part will go away or become
Yes.
otiose, and some part becomes otiose because the in 1957, some
Correct.
other part becomes OTOs
Correct.
later on. So you say one has a permanent feature. That is our
So
argument. we
Constituent
want to-
Assembly effectively had a choice to exercise three or to allow one to
Till
continue forever.
1957. Your argument is all these choices were available only till 1957.
Yes, that's a.
That is your argument.
So much. No, let's not debate it.
In fact, that's why the explanation to B contains an exhaustive definition of what is meant by the government of the state. Government of the state does not say includes the Maharaja. It says government of the state means the person for the time being recognized by the president as the Maharaja of Jammu and Kashmir,
Correct.
acting on advice of the Council of Ministers for the time being.
Right.
Now, what happens when the Maharaja is replaced by an elected government in Jammu and Kashmir?
Then the elected government on the aid and advice of the Council of Ministers.
Where do we
Governor-
get that? Because the explanation says government of the state means.
Well, I'll show that to your lordship. That's also there, Malad. It is part of the constitution, Malad. I'll show that.
This explanation was introduced in 1952. This
There's a difference of opinion here.
Leave it. Let's, you can.
Their case is that 2 and 3 may cease post 57. But some of us whose argument is that no, the entity goes if we read clause 2 carefully. So this is that difference of opinion.
So your submission.
Well, there is a government order of 1965 which says that Sadr-e Riyasat will be in the governor.
67.
Yes, 1965 order.
65. So till 65, did the Maharaja continue to?
Yes, Malad. Then,
There were separate powers of Sadr Riyasat.
Yeah.
The
but Malad, ultimately,
equivalent of chief minister is called the prime minister.
Yeah,
for
that's
some
correct.
period of time.
But in
Those
65, Malad,
terminologies
it was the
were,
governor.
removed.
There's an order to that effect. So be that as it may, Malad, I think we're traveling a bit too far at the moment.
And then governors, then give the order. So it's not anything that was done under the 70. JK Constitution.
Now kindly see, Malad, the preamble of the constitution, your lordships will find volume 2, PDF page 16.
Now we are looking at the J&K Constitution.
That the Constitution of India is applicable under J&K Constitution.
JNK Constitution.
J&K Constitution.
So that is volume.
Volume 2, PDF page 16. Yes. No, J&K.
You want us to go to page 16 of the
Page
JNK
16. Yes, the entire volume is that. Lordship has the preamble.
No, he-
Till 65. Till 65. There was an order in 65. Just kind of page 5, PDF page 5, volume documents, volume 2. Just it's the index, Mullahs, really. Right. Right.
So you referring to preamble at page 16?
Yes, but before that, Mullahs, just so that you know Mullahs, what the Constitution was dealing with.
Page 5 is part 3, you are saying.
Page 5.
You're wanting us to read page 5?
Contents, Mullahs. Contents. The state,
Yes.
permanent residence, directive principle of
that's what I'm
state
saying.
policy. PDF 5.
Yes.
Just the contents, Mullahs. Yes. You see now, part 1, part 2, part 3, part 4. And the directive principles of state policy now come in. Permanent residence come in. Then the state, permanent residence, directive principle of state policy, executive, governor, council of ministers, advocate general, contractor, government of business, composition.
Just 1 minute, Mr. This goes against because director.
Officers of the state legislature, disqualification of members. It's really a replication of what the Constitution, our Constitution provided. Procedure for financial matters, legislative power, high court, subordinate courts, finance, property, public services, elections, amendment to the Constitution. This is very important. I'll show that to your lordships presently. And then the schedules, speaker, deputy speaker, and all that. Now kindly come with us to the preamble. PDF page 16. So, we the people of the state of Jammu and Kashmir. Now, the Constituent Assembly has exercised its powers. Drafted the Constitution, adopted. We the people of the state of Jammu and Kashmir, having solemnly resolved in pursuance of the accession of the state to India, which took place on the 26th day of October 1947, to further define, this is important, to further define the existing relationship of the state with the Union of India as an integral part thereof. That's Article 1. And to secure to ourselves justice, social, economic, political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among us all, fraternity, assuring the dignity of the individual and the unity of the nation. In our Constituent Assembly, this 17th day of November, 1956, do hereby adopt, enact, and give to ourselves this Constitution. Now kindly see the definition clause. In this Constitution, unless the context otherwise requires, the Constitution of India means the Constitution of India as applicable in relation to the state. Right? Then kindly come to Muller's Article 3, the state. Relationship of the state with the Union of India, the state of Jammu and Kashmir is and shall be an integral part of the Union of India. And Muller's subclause 3 says, just above that, any reference in this constitution to the Sadr Riyasat shall, unless the context otherwise required, be construed as reference to the government. This is 1960, which my lord was asking that question. So, Mullah, this shall be an integral part of India. And then 5, Article 5, the executive and legislative power of the state extends to all matters except those with respect to which Parliament has power to make laws for the state under the provisions of the Constitution of India. Then, Mullahs, the issue of permanent residence is dealt with. We're not concerned with that so much. And then you come to 35, page 28, PDF 28. This is an important section, Malaj. Important article. 35. My lords have that. PDF 28. Council of Ministers to aid and advise the governor. There shall be a council of ministers with the chief minister at the head to aid and advise the governor in the exercise of his functions. All functions of the governor, except those under sections 36, 38, and 92, shall be exercised by him only on the advice of the council of ministers. So other than 36, 38, and 92, Malaj, he will act on the aid and advice of the council of ministers. Now kindly come to 38, 48A, PDF page 33. This was inserted, Malaj, in 1975. Not which,
Yeah.
is notwithstanding anything contained in this constitution, if upon the completion of a census, but before the final readjustment of territorial constituencies, the Legislative Assembly is dissolved prior to the expiry of its duration, and the governor is satisfied that holding of general elections without delay is necessary, he may, after consulting the Election Commission by notification, direct that the general election shall be held on the basis of the last preceding delimitation of territorial constituency. Then, Malaj, page, Article 53, page 37, PDF 37.
Article
53, Malaj, at PDF 37. That's the session of the legislature, prorogation and dissolution. The governor shall from time to time summon each house of the legislature to meet at such time and place as he thinks fit. But 6 months shall not intervene. These are the provisions of the Constitution also. Intervene between its last sitting in one session and the date appointed for its first sitting in the next session. The governor may from time to time prorogue the houses or either house or dissolve the Legislative Assembly. This he can only do it on the aid and advice of the Council of Ministers. It's not an exception because the exceptions are 36, 38, and 92. This is important because it really, the issue will arise because Malaj, there was no Council of Ministers when he did this, which is on the 21st of November, 2019. 2018. Malaj, the importance of this is that he can only dissolve the Legislative Assembly on the aid and advice of the Council of Ministers. The only exceptions that the governor has in the terms of his exercise of power are 36, 38, and 92, which he need not do on the aid and advice. But under 53, he can't do it without the aid and advice, which is what he did. Well, I'll come to that later. Now, Malaj, 92, which is that exception. PDF page 59. This is a very unique power given to the governor of Jammu and Kashmir. Yes. I was mentioning, Maharaj, as far as 53 is concerned, that power to dissolve the assembly would only be exercised on the aid and advice of the Council of Ministers. So when he dissolved the assembly on the 21st of November 2018, he didn't do it on the aid and advice. And this governor's power has to be exercised in that fashion. The only exceptions are 36, 38, and 92. And I'm now reading 92 for your lordship. This is also a unique provision. Provisions in case of failure of the constitutional machinery in the state. This is PDF, Mullards, 59. My lords have that. Does this call, Mullards? Your lordship have one?
Page 50.
59, PDF 59, Article 92. My lord have it.
Breakdown of.
Yes. Now, provisions in case of failure of the constitutional machinery, if at any time the governor is satisfied that a situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of this constitution, the governor may by proclamation, Mullards, assume to himself all or any of the functions of the government of the state and all or any of the powers vested in or exercisable by any body or authority of the state, make such incidental and consequential provisions as appear to the governor to be necessary or desirable for giving effect to the objects of the proclamation, including provisions for suspending in whole or in part the operation of any provision of this constitution relating to anybody, provided that nothing in this section shall authorize the governor to assume to himself any of the powers vested in or exercisable by the High Court. We are not concerned with that. But Maharaj, this he can exercise without the Council of Ministers, unlike in the Constitution of India. Why? Because Jammu and Kashmir has a unique status in the context of its relationship to the government of India. Yes. Huh? And Miller's clause 3 of this is important, that any such proclamation, whether varied under subsection 2 or not, shall, except where it is a proclamation revoking a previous proclamation, cease to operate on the expiration of 6 months from the date on which it was first issued. So, Maharaj, the proclamation was issued on November 21st, 2018, on 20th of June. It was to expire in 6 months' time on 19th December. And Maharaj, on November 21st, he dissolved the assembly. And without reference to the Council of Ministers. But anyway, we'll come to that a little later. Now, most important, well, is in the context of what we've been arguing all of yesterday and today, is 147, PDF 85, sorry. No, sorry.
Amendment to the Constitution.
Yes. Well, an amendment of this Constitution shall be initiated only by the introduction of a bill for the purpose in the Legislative Assembly, and when the bill is passed in each House by a majority of not less than 2/3 of the total membership of that House, it shall be presented to the Governor for his assent, and upon such assent being given to the bill, the Constitution shall stand amended in accordance with the terms of the bill. Provided that a bill providing for the abolition of the Legislative Council may be introduced in the Legislative Council and passed by it by a majority of the total membership of the Assembly and by a majority of not less than 2/3 of the members of the Assembly present and voting. Provided further that no bill or amendment, now this is important, provided further that no bill or amendment seeking to make any change in this section or the provisions of sections 3 and 5 or the provisions of the Constitution of India as applicable in relation to the state shall be introduced or moved in either house of the legislature. So, Maharaj, you cannot amend 370 as it is made applicable to the constitutional order made applicable to the state of Jammu and Kashmir. So no legislature can even move a bill. This is what makes it permanent. This is exactly why it is permanent. It had to be temporary because at that time there was no constituent assembly. It was temporary, it had to be temporary. Per force it was temporary. Even 3 cannot be amended. Section 3 cannot be amended.
But can the permanency of Article 370 be a consequence which follows from the Constitution of Jammu and Kashmir?
No, it's made applicable to Jammu and Kashmir by an application order.
No, but you're saying that this provision,
Yes.
Article 147 of the J&K Constitution,
Yes.
makes Article 370 permanent. Can the permanency of the Indian
Yes,
Constitution?
because, brothers, kindly see, the 370 was made applicable to the state of Jammu and Kashmir by an application order. 373, brothers, kindly. Subclause 3 gives powers to the Constituent Assembly, no?
Those powers clearly
Those-
doesn't have.
That legislature doesn't have those powers. Country middle what happens is when you impose Article 356, you took over the powers of the legislature. Under which power did they exercise that right?
Not of the legislative assembly.
Yes, exactly. That's what I'm saying, brother.
Mr. Sibal, how
But then
can
how
we,
is proviso C will applicable?
Yeah.
how can, you are saying Article 147 gives the permanency to Article 370?
Because the Constituent Assembly, I'm sorry, I shouldn't interrupt you, Lord.
Now, can the Constitution of J&K give a permanency to Article 370 of the Constitution of India?
Exactly.
Well, that's all we are saying is that the Legislative Assembly does not have the power under 370 subclause 3. That's all that I'm saying, nothing more than that.
What you are saying is legislative assembly cannot exercise the power under the proviso to
Yes, yes,
clause 3
yes.
of
So
Article
what,
370.
then
That's
what,
not-
that's why they did, they converted the Legislative Assembly into the Constituent Assembly. That's what they did, Malaj. This is what is shocking.
The lighter side, the Parliament did it.
I'm sorry?
On the lighter side, the Parliament did it.
Yes. So Parliament converted itself into the Constituent Assembly of the state. I mean, it's unheard of. Yes, no means what? We'll show it. We'll show it. We'll demonstrate that. At the moment, all I'm saying is, Millers, you cannot exercise, the legislature cannot exercise powers to amend 373. Yes, even some other body takes over those powers, that only powers can be exercised, is the powers of the legislature, nothing more than that. That's the whole scheme of 356 is if you take
Whether
over.
the Parliament can do it or not.
Yeah, well, Parliament exercises the powers of the legislature under 356. It can't exercise any other power. And that's the scheme of 356, which I'll come to later. That's Bomai, mothers. Now that's settled. You can't arrogate to yourself a power that the legislature doesn't have. That's why there's an interplay between the Constitution of India, the constitution orders applicable to the state of Jammu and Kashmir, and the Constitution of Jammu and Kashmir and 370 itself.
That's what you flagged in the beginning when you began your speech.
That's the issue.
Actually, Article 147, the second proviso to Section 147 of the J&K Constitution, would seem to indicate that the provisions of the J&K Constitution are treated to be subordinate to the Indian Constitution. Which is why no amendment in the relationship of the Indian Constitution and its application to the state can be introduced in the state legislature. The state legislature cannot change that relationship.
Correct, but I'm not disputing that. It is the legislature cannot introduce a bill to that effect. And what's the procedure? Only under 370. It's only under 370, Manoj.
But this is in that sense a subordinate instrument in its application to the
Well,
in its
it's-
relationship
it's a
to the
subordinate-
Constitution of India.
But let's kindly see, one second, kindly see, just 1 minute. Kindly see the Constituent Assembly has now framed the Constitution. The Constituent Assembly has not exercised the power that it had, Malaz, to abrogate 370. In that process, the Constituent Assembly, when drafting the Constitution, decided that nobody can change that status. The legislature cannot change that status. Now, whether Parliament on its own can change that status is a separate issue, but the legislature cannot change that status. That's the element of permanency as far as the legislature is concerned. Let me put it that way.
The legislature has no authority to change the relationship between.
That's correct.
That's what you're
Legislature
saying.
can change. Why? Because this is not a temporary provision. Come to that. That's clear, Manoj. Section 3. Same thing. Section 3. The Legislative Assembly also can't touch below the provisions that the state of Jammu and Kashmir and shall be an integral part of India. Section 3. It also can't touch extent of executive and legislative power of the state. Can't touch that. And it can't touch 370. So from the point of view of the Constituent Assembly, when the legislation was drafted and the Constitution was drafted, it was clear that this relationship is permanent.
Just one question, the proviso to Article 147 of the J&K Constitution says that no bill or amendment seeking to make change in the provisions of the Constitution of India is applicable
Yes,
in relation to a state
yes.
means a change in the Constitution of India. Whereas, as per clause 3 of Article 370, it's not the amendment which is applicable. As per that, it's the consent or the consultation or the,
Recommendation, neither consent nor consent, it's a recommendation
no. if
of
we-
the
Let's
of
see
the Constituent
373.
Assembly.
Let's see 373 for a
Yes,
minute.
please.
So really speaking, under 147 may have no application as far as, because you're not seeking to amend 370, but enforce 370. Let's assume, for the time being, substitute the words Constituent Assembly for Legislative Assembly. On the recommendation,
Yeah,
let's assume so.
let's
Substitute. You're right, it's
Correct.
recommendation.
correct.
Let's substitute that word, provided that the recommendation of the Legislative Assembly for the state referred to shall be necessary before the President issues such notification.
Yeah.
So really, 147 will not be applicable in case the state legislature makes that recommendation.
No, but let's kindly see what 147 says is the provisions of the Constitution of
But
India
you're not
as
amending the.
applicable in the relation to the state.
You're not amending the Constitution. You're not amending this Constitution of India. For the time being, let's read as it is, because what is barred under the proviso to 147 is amendment seeking to make a change in the provisions of the Constitution of India.
As applicable in relation to the state.
As it applicable in
Which
relation
is,
to the
which is
state.
why 370 is incorporated, Malad, in the Constitution of Jammu and Kashmir. As it stood then, that's the application order.
So
We're not talking about the Constitution of India here.
Sibal, doesn't it, I'm just thinking aloud,
Yes.
does it not mean that the proviso, the implication is that once the provisions of the Constitution of India are made applicable by different orders,
Yes.
you through an amendment cannot
That's all
deactivate
that
it.
we are saying. Nothing
You
more.
can deactivate a provision which has already been applied to the
Yes,
Constitution
that's all that we are saying.
of,
Nothing more than that. We're not amending the Constitution of India. We're amending the constitutional order applicable to the state of Jammu and Kashmir, which makes 370 applicable. And it can't even be moved in the House. Yes. And if it can't be moved in the House, it can't even move the bill. It can't be moved in Parliament.
as I see it, it's that you can't go back. Suppose after consultation, the CO has been issued, order has been issued, notification has been issued, certain provisions of the Constitution have been made applicable.
Yes.
Then it's not that a rethink can arise 10 years later and you start
That's all. That's all.
and say that, look, okay, we don't want to make some of the Constitution provisions
Absolutely.
already made applicable,
Correct.
not applicable.
So my argument is that the Constituent Assembly has exercised its choice. And it's evident from the provisions of the Constitution itself. So you need to read the Constitution of India, the orders applicable to Jammu Kashmir, the Constitution of Jammu and Kashmir, and 370. So under what provision of law under the Constitution of India can you change that? When you are doing it under 370, 356. So now, Malaj, this is now the lay of the land as far as this is concerned. Now I want to take your lordships to the judgment of Supreme Court, Malaj, of this court in the power of the constituent Keshav Nand, Malaj. Volume. This is it? T. No, no, no. Then I come.
So Sibal, is the factual whatever you had to say is over?
No, no, Maharaj, I'll go back because we are on the point of the Constituent Assembly and the Legislative Assembly. So Maharaj, that has to be clarified. Maharaj, a Legislative Assembly cannot be converted into a Constituent Assembly. My basic argument is that. Under what power can you convert a Legislative Assembly into a Constituent Assembly? Which is that power?
As a matter of fact, Praja Sabha was turned into a constituent assembly, 1951.
Well, there was a direct election, I believe, Maharaj, at that point in time. Rajya Sabha was not all directly elected. But I'll check that out, but I don't want to make a statement and I'm sure of it. No, there was not. I mean, I don't want to, Maharaj, give an answer without being sure of it.
Unless you are sure about it.
That's right, Maharaj. I always hesitate to do that, Maharaj. My learned friends are far more, articulate on those issues, Maharaj, than I am.
Seized by the Rajah, 1951. Just Sabha was by the power of Praja Sabha was conferred to the Constituent Assembly.
The power of Constituent Assembly was conferred on the Praja Sabha.
According to me, and I'll give that date, why should I, Maharaj, say anything? The Constituent Assembly was directly elected in Jammu and Kashmir, but I don't want to, Maharaj. I must be sure of it before I say that. I know, it says that Constituent Assembly consisting of representatives of the people elected on the basis of adult franchise shall be constituted forthwith for the purpose of framing a constitution. So I was aware of it, Maharaj, but I was not sure where it was. I just wanted to mention. Unlike Unlike us, we were indirectly elected, our constituent assembly. Anyway, let's kindly have a look at Keshavnan Bharati. This is volume 15. Volume 15 of
Yes, that's a good idea.
Case Law Compilation, PDF 236. Actually, 235. I'll start with paragraph 537. Volume 15, my lords. Volume 15, paragraph 537. Which is why I've been saying throughout my submissions, this was a political act to achieve a certain political purpose, dehorse the provisions of the Constitution. Page, my lords, 235, paragraph 537.
We've got it on the screen as well.
Yeah.
Sorry, Mr. Sibal, sorry. I just wanted to answer my Lord Justice Gavai's question. I just sought to be unmuted. My Lord, there was a proclamation by Yuvraj Karan Singh for constituting the Constituent Assembly on 20th April 51. It was elected by adult suffrage. This was convened on the 31st of October 1951, its first sitting, and my Lord, it concluded its work on the 17th November 56, when it decided to adopt the Constitution on the 26th of January 57.
That's correct. On this page, para 537 of PDF 235.
Whose judgment is this?
This is Malad's Justice Sheraton Grover. Well, the argument was that
Which page are you?
368 refers to procedure to
You are
amend the
referring to page number?
page 5, PDF 235.
35.
Volume 15, Mr. Sibal.
I'm sorry,
Volume 15.
volume 15.
Case law compilation.
Volume 15.
Case law
Case
compilation.
law
You also have that?
No, we have got something else.
Page 235.
It's with you, in case you want to see it on the screen.
537, 538, Mullahs. I just read 37. The argument was, Mullahs, that when the Constitution in 368 talks of amendment to the Constitution, it's a procedural argument. Where does the constituent power lie? That was the argument, and that in that context, the issue of what is a constituent assembly,
Yes.
that is discussed, Mullahs. It's in that context because we're dealing with that issue. 537, if I may read. It is pointed out on behalf of my lords, all my lords.
Yes.
It is pointed out on behalf.
Yes.
It is pointed out on behalf of the petitioners that the scheme of Article 368 itself contains intrinsic pieces of evidence to give a limited meaning to the word amendment. Firstly, 368 refers to an amendment to the Constitution, and the result of the amendment is to be that the Constitution shall stand amended. No. Yes, 235. My lords have it, my lords, not yet.
No problem.
constitution of its identity. The amending power is conferred on the two houses of parliament, whose identity is clearly established by the provisions of the constitution. It must be the parliament of the sovereign democratic republic. It is not any parliament which has the amending power, but only that parliament which has been created by the constitution. In other words, it must continue to be the parliament of a sovereign and democratic republic. The institution of states must continue to exist in order that they may continue to be associated with the amending power in the cases falling under the proviso. If the respondents are right, the proviso can be completely deleted, since Article 368 can be amended. This would be wholly contrary to the scheme of Article 368 itself. Scheme of 68, because two agencies are provided for amending the provisions covered by the proviso. One agency cannot destroy the other by the very exercise of the amending power. The effect of limitless amending power in relation to amendment of Article 368 cannot be conducive to the survival of the Constitution itself, because the amending power can itself be taken away and the Constitution can be made literally unamendable by virtually unamendable by providing for an impossible majority. While examining the above contentions, it is necessary to consider the claim of the respondents that the amending power under 368 has the full constituent power. It has been suggested that on every occasion the procedure is followed as laid down in Article 368 by the two houses of parliament and the assent of the president is given. There is the reproduction of the functions of a constituent assembly. Just mark. In other words, the parliament acts in the same capacity as a constituent assembly when exercising the power of amendment under the said article. This is fundamental to the entire argument that I make. In other words, Parliament acts in the same capacity as a constituent assembly when exercising the power of amendment under the said article. This argument does not take stock of the admission made on behalf of the respondents that the entire Constitution cannot be repealed or abrogated by the amending power. Indisputably, a constituent assembly specially convened for the purpose would have the power to completely revise, repeal, or abrogate the Constitution. That shows that the amending power under 368 cannot have the same powers as a constituent assembly. Even assuming that there is a reference on the nature of the power being enacted between enacting a law and making an amendment, both the powers are derived from the Constitution. The amending power has been created by the Constitution itself. It can only exercise those powers with which it has been invested. And if that power has limits, it can be exercised only within those limits. So you have a clear distinction between the exercise of constituent power and the exercise of legislative power, which is what I said in the beginning to your lordships. Parliament, while enacting a law, functions within the contours of the Constitution. A constituent assembly has no constitution in place. It has every right to do what it likes till such time as the Constitution is framed. So at no point in time in law can a legislative assembly be converted into a constituent assembly as a matter of law. Yeah. Luckily, we had no Maharaja exercising his powers with us. We had Parliament doing that.
And
Now,
even when Parliament amends the Constitution,
yes,
it's not exercising powers as a constituent assembly.
that's correct.
It may be exercising a constituent power,
That's correct.
the power to amend, but because it's a power which is restricted, You are subservient to the Constitution.
That's right.
And therefore, you're bound by the provisions of the Constitution, by virtue of which your power to amend the Constitution is circumscribed.
That's what I'd said at the outset, Mullahs. That has been my submission throughout. Now, the next paragraph, Mullahs, is paragraph 620. This is at PDF page 273.
Whose judgment is that?
This was Justice Hegde and Justice Mukherjee.
270?
Mullahs, 273 PDF, para 620 Mullahs. Otherwise, Mullahs, see the danger of this argument. Tomorrow, Mullahs, Parliament says that we are the Constituent Assembly. They can do away with basic structure.
Dr. Ambedkar also spoke about it in his speech on 25th of November, 1949.
I'm sorry, I didn't get your note.
Dr. Ambedkar,
Yes,
while presenting the final draft
yes,
on 25th of November 1949,
Yeah.
also spoke about this aspect
yes, yes.
in his
Yes, I
concluding
think
speech.
we have it, I think. We have it, I think, in volume 8. I just come to that. No, the point I'm making is a more fundamental point which impacts the future of our country. If you in principle say that a parliament can convert itself into a constituent assembly, then where do we go from there? Forget about this case. I'm far more worried about our future. Parliament can never say that, because that constituent assembly is a political process, which I said at the beginning. It's a political process in the context of the aspirations of all those participating in the constituent assembly as to what the state should be like. How do you meet the aspirations of the different segments of the community which have to be met, and what kind of provisions should be put in place? So it's the genesis of the politics of the day which determines what kind of constitution we want. Which is why, when you talk about diversity, when you talk about minorities, we talk about Dalits, we talk in our constitution, what were we faced with? In 1947, what were we faced with? We were faced with a situation where disparate communities, diverse communities, different religions, different races came together to be part of the Union of India, and their aspirations had to be met. So you had provisions with the Dalits, you have provisions with the minorities, you had provisions dealing with reservations, the scheduled castes, the scheduled tribes. That's a political process. That's why our constitution is what it is. Unlike, as I told, in Europe, it was an entirely different process. Here it was an amalgamation of colors to be united as one, which is the Tiranga. That's what it is. You can't convert a legislative assembly into that process.
But equally, Mr. Sibal, to completely divorce the power of amendment from the political process inherent in the amending power
Yes, of course.
would not be appropriate, because there's no strict dichotomy in that sense between the exercise of the constituent power itself being traceable to the political process and the power of a constituent assembly being entirely political in its nature. The constituent power itself of parliament to amend the constitution is a political power.
I agree entirely. Absolutely right. We're not saying you can't amend. Because it's not our case. You can.
But when parliament amends according to you, it is not exercising the powers of a constituent assembly.
That's all that I'm saying. That's all that I'm saying. It's not converting itself. And then it has to function within the Constitution of India. I'll come to that later. We're at a stage, Malad, where a CO is issued.
The constituent assembly is untrammeled.
That's right.
It's as if it is working on a clean slate.
That's correct. Absolutely. Absolutely, Malad. And it says, the judgment says so, Maharaj. That is not bound by anything. Bound by the representatives of the Constituent Assembly who have common aspirations to draft a constitution for the future of the people of the country. Which is why diversity, protection are fundamental to our constitution. For this reason, this very reason. So you want to take away that, that's very dangerous. I'm not being political, but that's the worrisome part. I reach 6:20 minutes.
20.
Now, coming back to Article 368, it may be noted that it has three components. Firstly, it deals with the amendment of the Constitution. Secondly, it designates the body or bodies which can amend the Constitution. And lastly, it prescribes the form and the manner in which the amendment of the Constitution can be effected. The article does not expressly confer power to amend. The power is necessarily implied in the article. The article makes it clear that the amendment of the Constitution can only be made by Parliament, but in cases falling under the proviso, ratification by legislatures of not less than one half of the states is also necessary. Normally, if you read the proviso, if you don't have the ratification, there'll be no amendment. You can't wish away the proviso. That article stipulates various things. To start with, the amendment of the Constitution must be initiated only by the introduction of a bill for that purpose in either House of Parliament. It must then be passed in each House by a majority of the total membership of that House, and by a majority of not less than 2/3 of the members of that House present and voting. And if the amendment seeks to make any change in the provisions mentioned in the proviso, it must be ratified by not less than one half of the state legislatures. Thereafter, it should be presented to the President for his assent. It further says that upon such assent being given to the bill, the Constitution shall stand amended in accordance with the terms of the bill. To restate the position, Article 368 deals with the amendment of the Constitution. The article contains both the power and the procedure for amending the Constitution. No undue importance should be attached to the marginal note which says procedure for amendment of the Constitution. Marginal note plays a very little part in the construction of a statutory provision. It should have much less importance in construing a constitutional provision. So, Mullahs, when your lordships talk about temporary, Mullahs, really you have to look at the Constitution. Because it had to be temporary in 1950. There was no element of permanency. It could not have been. And this is the marginal note. Give it to my lord. You have copies?
This is a marginal
Give it to
note.
the
There's
other
no
side.
question about it. It is a marginal note.
Yes. So, Mullahs, you can't be saying, which is what your lordships are concerned with, but it was temporary. But that's only when you look at the marginal note. It had to be temporary because there was no other way to deal with it. You couldn't have said it is permanent.
There's no doubt still about the fact that this forms a part of Part 21 of the Constitution, which still deals with temporary and
But those
special
are
provisions.
different, Mullahs. I'm not disputing that. These are all different provisions, Mullahs. If your eye look,
They've all been clubbed together in Part 21.
that's correct. But we looked at it in the context of, Mullahs, what was going to happen in the northeastern regions. Gujarat and Maharashtra together, what was to happen there, issues of Marathwada. So those councils had to be created, boards had to be created. That's why they were temporary. Telangana, that's why they were temporary. Not for any other reason. And that's why this was also temporary. It's the same logic. But the fact that it is temporary doesn't mean that the article is temporary for all time to come. You can't interpret the marginal note in that fashion. So the language of 368 to our mind is, I'm sorry.
317, it is actually good. देखो क्या मैंने
If you look at the heading, Millers, it says temporary and transitional provisions. So 2 is temporary and 2 is transitional and 3 is temporary.
It's 368 power, right?
In this case, no, 356 power. No, it's 356 because they converted. What happened? Well, let me just, in one sentence, they say, in one sentence, I'll tell you what they did. They converted the Legislative Assembly into the Constituent Assembly. Right? Right, dissolved. They converted it into a Constituent Assembly. Then they said that now Parliament, because of 356, Parliament is exercising that power. So the Parliament is the legislature. And because it's a Constituent Assembly, Parliament of India is the Constituent Assembly, and therefore we can do what we do. That's in one sentence what they did. And they recommended to themselves. So instead of clapping by 2 hands, they clapped by 1 hand. Because they exercise the power of the legislature themselves. And because the legislature's consent was necessary to give that consent to themselves and abrogated 370. Unique, constitutionally a unique, unheard of. I will not use that expression. A procedure that is unknown to law. Because the objective was entirely different. And I've been saying that from day one.
That's how they brought in the
10 minutes. Seven is a different issue. It's on the definition. I don't think so. Discuss that. Discuss it.
to apply the proviso to clause 3 of Article 370.
Yes, yeah, because they understood it that way, that it required the previous.
And then what they do is they say that the Parliament exercising the powers of the Constituent Assembly
Yes.
by virtue of the fact that the Legislative Assembly has been dissolved.
Yeah.
assuming that the Legislative Assembly was not dissolved, that could have exercised the power of the Constituent Assembly.
That's right.
Now that it has been dissolved,
Yes.
under 356, Parliament has the power to make laws with all aspects of whether it's
Correct.
list 1, list 2, or list 3. And then they exercise the power under the proviso.
That's right. That's right. So, Malad, actually, they understood 370 sub-article 3 in the manner in which I am, Malad, stating before your lordship. It is their understanding right till the end. They don't understand. Which is why I wanted to bring it at this stage, Malad, so that now your lordship knows, Malad, the larger picture, so to say. So we are going into interpretation of 370 sub-article 3, which they themselves accept, that the proviso applies. No,
We'll come back after lunch. Mr. Sibal, if you can just in a very brief while, take us through the process which was followed. We can go straight to that. Now we've understood anything more in Keshwananda apart from these four judgments? All right, we'll see that and then so that we come to the end of then reading Keshwananda.
But yeah, 25th November.
If you lordship sees the facts